Hi, my name is Alex Dolphin and welcome back to another episode of Ex Ante. Today we're going to discuss the case of Stees versus Leonard. This case is heard in the Supreme Court of Minnesota in the year 1874. Let's go ahead and jump into the facts of the case. Stees had contracted with Leonard. Leonard was a builder to erect the building. Leonard was meant to build this building. Stees was paying them to have this building built. Leonard went ahead and started building this building. When they got to the third story, the building collapsed. It was because the soil was soft. So Leonard went ahead and tried again, and give it another shot to try and build this building. So they got again to the third story, and the building collapsed. So both times, twice, Leonard failed at erecting the building. They blamed it on the soft soil. Leonard was so frustrated at this point, the contracting company, they just decided, you know, we're done. We're not going to try and build this building. We gave it our best effort, but, basically screw you guys, Stees. Appreciate, you giving us the business, and we were trying, but we just couldn't get it done. Well, Stees had paid Leonard over $5,000 to have this building built, and they had a contract where it said Leonard would build this building for Stees. So Stees said, well, you can go run away, but I'm going to take you to court. So Stees took Leonard to court and sued, saying that, hey, you said that you were going to build this building. We've given you these payments. We want the payments back, and we want you to build the building. The judge then had before him the question of, who assumes this risk? There was a risk inherent in building this building of, the building collapsing while it's under construction. Doesn't seem like it's exactly the fault of Leonard that the building collapsed. It was because of soft soil conditions where the plaintiff, in this case Stees, wanted the building to be built. Ultimately, the judge decides that the risks in this case are allocated with the person who was building the building, so Leonard. So they ruled in favor of Stees and said that Leonard, because they signed a contract and said that, hey, we're going to build you this building, they have to build the building. So they ruled in favor of Leonard, and very succinctly, the court says, whatever was necessary to be done in order to complete the building, Leonard was bound by the contract to do. Leonard was bound by the contract to build the building. They breached the contract by not building it. Therefore, they're liable for the damages of the breach. This is an interesting case because it talks about allocating risks and how does the court want to allocate risks? When private parties don't allocate risks between themselves, right? Because Stees and Leonard didn't have a clause in their contract where it said if the soil is soft and the building falls down twice, who's going to pay for it? That wasn't a feature of the contract. That wasn't exactly explicated when the negotiations were ongoing. So the court says because that wasn't explicated, we're just going to let the risk lie where it fell, where the building fell in this case. So they're going to let the risk sit with Leonard and the contractor, because the lawyers in negotiations didn't contract around the possibility that, hey, maybe the building will fall twice. Therefore, Leonard was bound by the terms of their contract to erect the building. So the ex ante implications of this case are mostly going to be in the future in how lawyers want to draft contracts, how private parties want to draft contracts, and it incentivizes people to be more specific with languages, like with language of what will happen if certain unforeseen events do occur. This wasn't exactly super foreseeable to the party of Leonard, but the court ruled that it was foreseeable enough that Leonard needed to take care of this. But what it's going to do is incentivize attorneys to draft around these risks and say, hey, if the building falls down twice because we're not able to erect it because of some, external circumstance such as the soil being soft, well, maybe then the third time we're going to split the additional costs of building that building. So it just incentivizes parties to be even more specific when they're explicating out possible scenarios in a contract. It incentivizes mostly the contractor, the person who's going to be building the building, to say, hey, if these scenarios occur, then, hey, we need this type of money. So thanks so much for watching. I hope you enjoyed this video. If you do like it and you'd like to see more, go ahead and hit that subscribe button. I hope you have a nice rest of your day. Bye.